Good morning. My name is Chad Griffin, and I'm the president of the American Foundation for Equal Rights. I'm going to introduce those who are before you today, and then our attorney is going to take a few questions. For those of you who have not met, Jeff Zarillo and Paul Katami, our plaintiffs, and Chris Perry and Sandy Steer, for those who have not yet met the plaintiffs in this case. And with that, I would like to now introduce our attorney, Theodore Olson.
Thank you, Chad. I wanted to say a couple of things preliminarily, and then we want to entertain your questions. First of all, I am very, very honored to stand up here with our plaintiffs, who are wonderful people, and I hope that you will get to know them well during the course of this litigation. They are wonderful people, and it's very, very, I was telling them after the hearing today how honored I am to be in the same courtroom and to be speaking for them. Secondly, I want to say that how much we appreciate the attention that Chief Judge Walker is obviously giving to this case. He's spent a lot of time already on the briefs that were filed by the parties. He wants to do this in the best possible way. He appreciates the fact that this case may go on beyond this court to the Court of Appeals and ultimately perhaps to the United States Supreme Court. He wants to make sure, as he said today, that he wants it done right and that there be a foundation established for the litigation that goes on. Now, we brought a motion for a preliminary injunction because we wanted to bring to the attention of the courts and to the public generally that the denial of individuals, such as my colleagues, my clients here today, of the right to marry, the right given to every other citizen in California, is an unconstitutional violation of their rights that causes them irreparable, immediate injury every single day that prohibition is enforced. They are entitled to relief from that constitutional violation as soon as possible. The California Attorney General, to his credit, has admitted that Proposition 8 is unconstitutional. Therefore, we have individuals who are suffering unconstitutional injury as a result of a provision of a California state law that the state of California, through its chief law enforcement officer, admits is unconstitutional. The suggestion was made by the governor that it was important not to grant an immediate injunction to allow the plaintiffs and the individuals in their situation to marry because there would be some uncertainty until the case was over. We understand that position, and we understand the judge's interest in having a final trial to go forward as soon as possible. However, I did make the point that my clients would prefer the uncertainty of the outcome of this case to the certainty of immediate, everyday, irreparable injury. Nonetheless, we accepted and we do respect the judge's decision that we should go forward to a full trial and get a resolution of this case on the merits, and that would be in the best interest of everyone concerned, and we defer to his wisdom and good judgment. So that was what, and as you saw today, the judge agreed to move this case expeditiously. He set another hearing for August 19th, in which we will be back here before the judge. Between now and then, both of the parties or all of the parties will submit materials. Between now and August 7th, we will get together with the proponents of Proposition 8 and try to agree upon as many facts as we possibly can to make the judge's job as simple as possible and as efficient as possible. We believe that we'll be able to agree on many facts, and we will be able to put forth evidence that supports the conclusions that we urge on the court through the form of affidavits, matters of public records such as the ballot materials that went with Proposition 8, findings that have already been made by the California Supreme Court that individuals who are denied the right to marry on the basis of their sexual orientation have been branded and continue to be branded as second-class citizens. Those matters are already been decided, and many of those facts will be brought before the court. So we hope that through the process that the judge adopted today, we will resolve many of the remaining issues, and that then what is left we will talk about with the judge on August 19th and develop a procedure as rapidly as possible to move to a resolution of this case. That's where we stand. We're very, very anxious to proceed. As I told the court, we are ready, willing, and able to proceed as rapidly as the court is willing to permit us.